Welcome to Dorsey's Bank Counsel Roundtable, Go West, Expanding Your Bank into California. I'd like to introduce Nick Vlietstra, a partner in Dorsey's Finance and Restructuring Group and co-chair of the Financial Services Regulatory Group. Nick?
Thank you, Rima. Good afternoon, everyone. This is Nick Vlietstra, and welcome to Dorsey and Whitney's May session of the Bank Counsel Roundtable. We've planned a 60-minute presentation entitled Go West, Expanding Your Bank into California. Thank you very much for joining us today. I have just a couple of housekeeping items I wanted to mention. First, please remember to sign in on the attendance form we provided and return it to attendance@dorsey.com. If you're still looking for your attendance sheet or for today's presentation material, they are both available for download from links in the email that you would have received yesterday from events@dorsey.com, and it's entitled Dorsey Webinar Reminder. Second, if you have any questions you'd like to ask our panelists, we invite you to contact them directly later using the contact information provided in the presentation materials. Or, of course, you can reach out with questions by getting in touch through your usual Dorsey relationship contact. And then may we have the next slide. We have four speakers on today's panel. They are Erin, Bryan, Hoang, Joe Lynyak, and Gabrielle Wirth. By way of introduction, Erin Bryan is a partner in the Finance and Restructuring Group in Minneapolis and is co-chair of Dorsey's Consumer Financial Services Group. Erin is also a member of the American Bar Association's Banking Committee, and Erin works in Dorsey's Minneapolis office. Hoang is also a partner in Dorsey's Minneapolis office, specializing in corporate governance and SEC compliance, securities, and M&A transactions. Joe Lynyak is a partner in the firm's Finance and Restructuring Group and is a nationally known regulatory lawyer, practicing out of Dorsey's Washington, D.C. and Southern California offices. Gabrielle Wirth is a partner in our Labor and Employment Group and works in our Southern California office and our Missoula, Montana office. She is head of the firm's Southern California and Montana Labor and Employment Practice Groups. More detailed bios on our speakers are in your materials, as is their contact information. And with that, I will hand it over to Joe Lynyak. Thank you.
Thank you, Nick. Good afternoon, everyone. I certainly hope that everyone is well and safe as we're rounding out this pandemic and opening things up. The genesis of this presentation was our experience, which continues at a pretty rapid pace, where our banking clients, and that includes national banks, state banks, and bank holding companies, will invariably call up and say, gee, I think we need to go to California. And we thought it would be very, very helpful to lay out for the attendees the complexities of what's necessary in order to be able to do that, what you need to look at, how do you go about doing an acquisition, how do you go about entering, and we'll show you both directly and indirectly some of the considerations. And now, I guess the question is, why do you want to go to California? Well, everyone wants to be in California, and everyone ultimately wants to be a Californian. It's the fifth largest economy in the world. We have got the coolest people. Every day is Cinco de Mayo here. And we're also probably the most creative people because we've got Silicon Valley, we've got Hollywood, and we lead not only the nation but the world in terms of moving the dial forward. Banks are no exception. In terms of banks and California, the population is a little under 40 million at this point. That's 10% of the total US population. The number of California licensed banks is 108 as of this point. A total of 200 banks located in California, and that would be California licensed banks, regional banks, national banks, and international banks. The number of, in terms of the California licensed banks, there's about 700 billion in deposits, and in assets, and about $600 billion in deposits, and a total deposit base in the aggregate of all banks of a little under $2 trillion. And so, in other words, there's money in them there hills. What are we going to look at? Well, we're going to describe, for purposes of entering into California, the federal regulatory scheme, the California regulatory scheme. Cam is going to talk about direct acquisition of a California bank, whether that's a state bank or a national bank that's located here. We're going to talk a little bit about interstate deposit and lending operations, which are possible. Then we're going to talk about alternative entry vehicles, including the use of affiliates, such as through a holding company. And then we're going to talk about the absolutely crazy California law to give you a flavor of what you need to deal with if you decide to enter the state. And in terms of the federal regulatory scheme, what happened in the 1990s, due to the strong statutory authority of federal savings banks and federal savings and loan associations, they were able to branch on an interstate basis at will. However, the state banks were not able to do so. And what broke out there was competitive problems as to whether or not particular federal savings banks would be able to branch and take over operations at the because of the competitive advantage. And what happened was, in Congress, they heavily negotiated what became the Regal-Neal Interstate Banking and Branching Efficiency Act. And that is the starting point on the federal side for being able to branch across state lines. What are some of the things that it did? Well, first of all, Regal-Neal Act is embedded in Section 44 of the Federal Deposit Insurance Act. It allows individual states to continue to prohibit interstate mergers. And that was because the states were concerned that you would come in, if you were a very large bank, buy somebody, and all of a sudden take over the state. It allowed individuals to prohibit interstate mergers. It did not prohibit former mergers. And importantly, it would only allow branch transactions, meaning an out-of-state bank could acquire a branch of a state bank if it was specifically allowed to occur. In other words, you couldn't just come in and buy a branch of a California bank and not the entire bank. That would theoretically be prohibited if state law decided that they wanted to go that route. What else did Regal-Neal do? Well, Regal-Neal also allowed a state to avoid an end around on the prohibition of acquiring a full California bank by prohibiting the ability to acquire a bank that is 5 years young or less. It imposed some pretty complex state merger rules and federal merger rules, which Cam is going to get into. Talked a little bit about aggregate deposit limits, which have really very much gone by the wayside. Talked about everyone's favorite Community Reinvestment Act issues. It required a bank to come into another state to be well capitalized, well managed, addressed discriminatory taxing provisions, antitrust laws, which now are virtually non-existent in terms of the bank merger analysis. However, it did say that once you got in here, if you were an out-of-state bank, you could then begin to branch in the same manner that a state bank could do so. And it also did not affect state usury laws, which are very complex, and we will touch upon them in a few minutes. In terms of the federal regulatory scheme, how did Regal-Neal translate out? Well, you see here the Interstate Bank Merger Act application, the interagency one, which is put out by all the regulators, and it is embedded in that guidance. The FDIC has got a policy statement on Bank Merger Act transactions, and then the OCC has got a very comprehensive and very well-defined manual on business combinations and their licensing manual. And again, you can take a look at that. And again, throughout it, it talks about Regal Neal. Just to touch base for a moment, we want to point out that the FDIC's policy statement on merger transactions talks about a lot of things that you need to do if you're going to be doing a merger, talks about the application filing, the publication of notice, which, taking a step back, everyone always messes up because they can never do it properly. And so you really have to pay attention to it. Competitive factors issues, you can have, and depending upon the situation, the Attorney General of the United States may have to be notified. Prudential factors, convenience and needs, which is something which was important maybe about 30 years ago. It's really not that important anymore. Antitrust laundering, very important factor, which has to be looked at very carefully. I mentioned Regal Neal, interstate bank merger considerations, branch closings, which addresses the fact that they do not want you to come in, buy a bank, and then start closing willy-nilly branches or closing them in areas of underserved communities, and then issues in terms of the names of banks and other intellectual property. Let's turn for a moment for the counterpart to Regal Neal, which is the California regulatory scheme. And what's important here is California and the California Bankers Association was adamant about protecting their own banks and protecting their own banks from someone coming in and buying just a branch as opposed to the entire bank. And a little bit of nomenclature is important here. When you take a look at the California Financial Code, it talks about foreign other state banks. And that refers to a bank that is located outside of the state of California that is seeking to come in. And what they did in terms of branches is in the California Financial Code, they said that we expressly prohibit coming in and simply buying a branch of a California bank. And that was pretty important. And because what that did, it protected individuals who currently owned the bank to be able to cash out and sell their bank to an out-of-state bank that would want to come in. However, you could buy, once you decided to buy a bank, you could then establish de novo branches, and that was the balance which was reflected also in Regal Neal. And then also it addressed the fact that when you bought a bank and you're going to do a merger, there was a complex series of compliance, government, corporate compliance, and governance approvals and so forth. In other words, you have to comply with federal, California, and foreign other state bank laws in order to be able to approve the transaction. And so again, that's something that Kim is going to talk about at the moment. So you can see it's a complex set of regulations which you have to navigate your way through. And I'm going to turn it over to Cam now to help us do so. Cam.
Thanks, Joe. So just to start off, I'd say at the outset of any proposed M&A transaction, it's going to be important to assemble your core team. And it's going to include investment bankers, lawyers, tax advisors, and subject matter experts who can help you identify and evaluate likely targets and also assist in brokering the deal. A very basic decision will be how to structure the acquisition. So whether it's a merger versus a stock purchase versus an asset purchase. And buyers will want to consider how the target is going to fit into their existing organizational structure. Where there is a holding company, the acquisition will need to be structured both at the holding company level as well as the bank subsidiary level. Tax considerations will be fundamental. So can the transaction be structured as a tax-free reorganization? As between a stock versus an asset purchase, sellers often prefer stock purchase for capital gains tax treatment, while buyers like the stepped-up basis of an asset purchase. A 338H10 election, which is a stock purchase that's treated for federal income tax purposes as an asset purchase, may be an acceptable compromise, but parties have to be prepared to negotiate how the tax benefits will be allocated as between the parties. In terms of assignment and assumption of assets and liabilities, there are generally fewer third-party consents required for a stock purchase because the target's contracts remain in the name of the target. But even for stock purchases, a change of control may trigger third-party consents. There may be assets or liabilities that the buyer wishes to leave behind by using an asset purchase structure instead of buying the bank through a stock purchase. But keep in mind what Joe was just saying, out-of-state banks can't buy branches from California banks and must buy the entire bank. So is an asset purchase even feasible? Once again, a theme you're going to hear throughout this presentation is that there are overlapping requirements of the Regal-Neal Act, California statutes, and federal agency requirements that can be quite complex. So you're going to have to parse through all of that and the approval process carefully so that there aren't unanticipated regulatory objections to the transaction. As for regulatory efficiency, consider whether the target will operate as a standalone entity, which will add administrative and regulatory complexity, or will it be merged into the buyer's existing bank? So people on the call, we're all familiar that each bank has an infrastructure in place for compliance, risk management, IT, accounting operations. So if two banks become one, you're able to consolidate all of that. As for branding, will the target keep its brand either as a standalone entity or as a division of the buyer, or operate under one of the buyer's existing brands? Turning to the form of consideration that you would want to use in the transaction. So for those buyers who wish to offer stock to target shareholders, they will need to register the shares or find an applicable exemption under federal and state securities laws. In California, there is a fairness hearing process that's conducted by a hearing officer of the Department of Business Oversight, which includes notice to shareholders and an information statement that's distributed to shareholders. And it can be an inexpensive alternative to SEC registration. It's authorized by Section 3A10 of the Securities Act. For private companies, stock awards that are issued in the transaction must comply with California law. So for example, a vested option must be exercisable for at least 6 months following termination due to the employee's death or permanent disability, or for at least 30 days for termination without cause. Next slide, please. So some common areas of focus for due diligence include regulatory compliance. For example, at the federal level, the target needs to have a rating of satisfactory or better as of the most recent CRA examination, and the target should demonstrate compliance with anti-money laundering rules. I'm skipping over a raft of state and federal level regulatory provisions, but for sure this will be a central focus for due diligence. In the process of evaluating asset quality and loan portfolios, the buyer will want to review a watch list of substandard loans and confirm that the allowance is in compliance with the target's existing methodology, as well as adequate under all applicable standards. The seller needs to provide evidence of good and marketable title to all owned real property, including OREO. Are the properties in compliance with applicable environmental regulations? I've definitely seen environmental inspections at branch locations hold up deals. Buyers also need to understand the employee base and employee benefits and plan for the transition of target employees to the buyer's programs. A key condition to closing will be regulatory approval. So promptly after signing, the parties need to cooperate to prepare these filings, and the buyer needs to file them. And they may include consents and/or approvals from any of these following agencies: the DFPI for state chartered banks, the OCC for the nationals, FDIC for state banks chartered under the laws of another state, and the Federal Reserve for a holding company transaction subject to the Bank Holding Company Act. In an M&A transaction, governance considerations include whether the target officers and directors will be asked to stay on either at the holding company level or the bank subsidiary level. Keep in mind that a target executive's involvement in the subsidiary bank's business pre-acquisition may prevent them from serving as independent directors for their surviving entity, which is a particular concern for public companies. The retention of key employees, non-competes, and non-solicitation should be addressed early in the process. So really aim to execute those employment agreements along with the purchase agreement, or run the risk that their negotiation may delay closing, which does happen. When negotiating employment agreements, keep in mind that the California statute provides that non-compete agreements are unenforceable except in very limited circumstances, such as in connection with the sale of a business. but then only to the extent reasonable and necessary in terms of time, activity, and territory to protect the buyer's interest. In addition, California courts generally will not enforce non-competes governed by the laws of another state unless the non-compete would be enforceable under California law. Next slide, please. It's important to pay attention to state corporate laws governing the business combination, obviously. So while subsidiary banks are usually governed by their home state corporate law, most bank holding companies and national banks have adopted Delaware corporate law. So just wanted to point out a few significant differences between the California Code and the Delaware General Corporation Law. It includes that there's more flexible timing actually for target shareholder approval in California. So California requires the principal terms of a merger versus the actual merger agreement itself to be approved by shareholders. And so this shareholder approval can happen either before, concurrently with, or after board approval and signing, which can be a really useful mechanism because it can eliminate delays between signing and shareholder approval, which does raise the risk of competing bids. In California, there is a limited right of a buyer to cash out the target's minority shareholders. And so the state limits the ability of a buyer in a two-step acquisition transaction, such as a tender offer followed by a second step merger, to cash out those untendered minority shares unless there is a minimum tender of 90% of shares. Without this minimum tender, minority shareholders must receive non-redeemable stock unless all holders of the class consent otherwise. A merger has to be approved by holders of each class of outstanding shares, unless there is a higher threshold that is required by the target's charter. So even shareholders holding less than a majority of total outstanding can block a merger in California. And finally, in certain circumstances, California law requires an affirmative opinion as to the fairness of the consideration to target shareholders if the transaction is with an interested party. Next slide, please. And just because the surviving bank is not incorporated in California, don't think that you're necessarily safe from the long arm of California law. So there are certain California statutes that apply to companies that are not incorporated in the state. Section 2115 imposes various corporate law requirements on private corporations from other states, including Delaware, if they, number one, conduct a majority of their business in California, and this is measured by property, payroll, and sales tests. And number two, if they have a majority of their outstanding voting securities held of record by persons having California addresses. These requirements address shareholder approval, dissenters' rights, limits on corporate distributions, indemnity of directors and officers, and mandatory cumulative voting for directors. And so the California statute can really have a profound impact on how you would run the business going forward. And it's led to something of a battle between the California and Delaware Supreme Court. So in 2005, Delaware held that Section 2115 is invalid as applied to Delaware corporations. But California's response has been ambiguous so far. The California Supreme Court has not invalidated Section 2115, so we should really treat it as good law for now. And then there are certain sections of the California Code, which is popularly known as Senate Bill 826. It's already been passed, that require publicly held companies that are headquartered in the state to include board members from underrepresented communities, which can have a profound impact on the governance of the business. And currently there's a proposed Senate Bill 260, which would mandate annual audit disclosure of greenhouse gas emissions by any US entity with over $1 billion in annual revenue doing business in California. So that covers my section on direct acquisition strategies. I'm going to turn it back to Joe to discuss other alternative entry options.
Thank you, Cam. And if there's anything which is very, very clear, the whole area is very, very complex and requires significant planning, due diligence, and making determinations of the degree to which compliance is necessary, whether it's based upon California law, Delaware law, or another host state law. But people may decide before they push the button and make an acquisition that it may be better to try to effect an entry into California in a different manner. And we're going to talk about a few of those things right now to give you a flavor of, again, considerations under California law and federal law that's necessary in order to be able to enter. We're going to talk a little bit about branching, talk about the use of a so-called facility, a decision, well, why don't we simply make loans into California, doing it on an interstate basis? And then we're going to talk about the use of affiliates that actually enter California. As we mentioned a while ago, under Regal Neal, while you're limited to buying branches from a bank in order to enter California, once you get in here, a foreign other state bank may establish branches in California. And there's some very, very strange, somewhat antiquated language in the financial code that talks about conducting a so-called core banking business. And that was put in place after Regal Neal because there was an attempt to try to regulate how people conduct business coming in and out of California. And core banking business is the business of receiving deposits, paying checks, making loans, and other activity that the commissioner of the CDBO or the would require, specify by order or regulation. And now the CDBO has become the DFPI, which doesn't roll off your tongue very well, but in other words, that's the new term of it. And registration is required if you're going to be engaged in branch banking in California with a core banking business. However, it's probably preempted under federal law for national banks, not something that you necessarily have to worry about. But again, it's still sitting there. Now, what if you're not engaged in core banking activities? Well, a foreign other state bank is authorized to open a so-called facility at which non-core banking business is conducted. And that's defined to mean all activities permissible for commercial banks, industrial banks, or trust companies, except core banking business, and except those activities prohibited by law or determined not to be non-core banking business. Kind of strange, but what it would effectively do is allow people to open up what many people viewed as representative offices in California, again, but not core banking. It's probably not as applicable as it used to be, but one of the things which is kind of interesting when you compare core banking to non-core banking is that people will use the term, well, it's a California chartered bank. Well, it's really not a California chartered bank. It's a California corporation licensed to conduct banking activities. And that gets very, very peculiar when you parse through what that means. Because many, many years ago, we were involved in the rewrite of the California Financial Code for banking provisions and realized that that was the case and stripped out all the provisions which authorized a California licensed bank to conduct activities, because if you're a corporation, you could do it anyway. A banking business, though, was limited to those activities defined as a core banking practice. And so what you end up with is the anomalous situation where a California licensed bank can do anything, including if it wants to acquire an aircraft carrier. That's kind of fun. And when the FDIC found out about this and realized that after we made those changes to the California Financial Code, they decided to pass Section 24 of the Federal Deposit Insurance Act, which said that, okay, maybe you can acquire a aircraft carrier, but first you have to get our permission. And guess what? It's not going to happen. And the only thing you can really do under state law is in banking is conduct banking activities which are permissible for a national bank. And what you have as the years have gone on, as you know, is a significant expansion of what constitutes banking activities under the National Bank Act and so forth. But still, in terms of activities in California, if you're going to have your California bank engage in strange activities, you've got to get the FDIC's permission. Well, what other things do you have to worry about? Well, a lot of our clients will say, listen, what we really want to do is we want to engage in, engage in interstate activities. We'll use the internet, we'll open up accounts and do those things, make loans across state lines. And the California Corporations Code, to some extent, permits that to occur. And what it specifically states in section 191D of the Corporations Code is that California recognizes that you can exercise rights under section 85 of the National Bank Act and section 27 of the Federal Deposit Insurance Act to export your interest rate into California. And you can utilize the interest rate in effect where a bank is, quote unquote, a national bank or state bank is, quote unquote, located. We do not have time today, or probably for the next week, to explain the mythology of what it means to be located for a bank. But suffice it to say that it's not as useful as it used to be, because California, within the last 20 years, has strongly adopted what is known as conflicts of law second, that states that if a state determines that something is critical to the operation, to the protection of its citizens, it can apply the law of the state, meaning California law, notwithstanding the fact that you're engaged in interstate activities. And that really does create a conundrum in that you've got to do some real significant planning as to what law you are going to adopt. And why do I say that? Well, the California state motto is non sumus alteria provincia, sumus alteria planatia. And what that is, when you translate it, that's the first time I've ever been able to use my undergraduate degree in classical languages, is we are not another state, we are another planet. And if there's anything you take away from this, take that away. California is very, very strange, and you have to understand the laws that you're getting into. And now I'm going to turn it over to Erin Bryan to talk to you about some of the craziness.
Thank you. The quirks and surprises that one encounters in California law are endless and continually expanding. So it's not surprising that a state as populous and economically significant as California would have complex laws in nearly every area, or that those laws are often far more expansive than what other state legislatures have produced. California law contains traps for the unwary in nearly every area, whether that be contracts, torts, criminal law, debt collection, property transfers or acquisition, taxation, zoning, and as we'll hear shortly from my colleague Gabrielle Wirth, labor and employment. I'm going to skip ahead a slide to briefly mention applicable federal law and preemption before we go in depth about the entry strategy and use of affiliates. Great, thank you. Yes. Something that frequently does surprise our clients who are expanding their interstate lending programs and banking services into California is that they will often need to consider that California generally takes the position that its consumer finance laws are not preempted by federal law. As Joe mentioned, California will often argue that a particular issue is a matter of overriding state concern. So even areas of law that have been taken up by the US legislature may not be preempted by California law, vice versa. Now, national banks will frequently use an alternative entry strategy to enter California, which is the use of subsidiaries and affiliates. For example, through a holding company subsidiary that is a non-bank. If you go back to the other slide, with respect to non-bank affiliates and subsidiaries, I note that under Section 25BE of the National Bank Act, the Act provides that a state consumer financial law shall apply to a subsidiary or affiliate of a national bank other than a subsidiary or affiliate that is chartered as a national bank, to the same extent that the state consumer financial law applies to any person, corporation, or other entity subject to such state law. So let's keep that in mind as we now go to the other affiliate slide. As a non-bank, an affiliate becomes subject to all of California's licensing laws and regulations, including California financing law, the California Residential Mortgage Lending Act, and California real estate law. California consumer finance and real estate laws are legendary for their complexity and, some might argue, the overregulation of these areas. But whether you agree or disagree with the hands-on approach that the California state government has taken with respect to consumer lending and finance, it must be acknowledged. And these laws can only be ignored at your peril, given the robust enforcement programs and active consumer bar in that state. As we'll discuss more in a minute, California leads the way in state examination and supervision activities. For example, with respect to licenses, California is sometimes called a stacking state. By stacking, I mean that an entity may have to stack licenses on top of each other, depending upon the activities it is conducting. So the licensure analysis becomes a heavier lift than what we encounter in many other states. California has expanded the use of NMLS to include many of these licenses, which is helpful. Your initial planning for license applications should begin with a review of that platform, which contains the forms of applications as well as various checklists of requirements. California will require a significant amount of background information for new applicants, as well as business plans, principal party information, etc. So this should not be an afterthought as you work toward your California expansion. Next slide. A fascinating but heartburn-inducing recent development in California has been the 2020 to 2021 reorganization of the California Department of Business Oversight, or DBO, into the California Department of Financial Protection and Innovation, or DFPI. Compared to the DBO, the new DFPI will have greater resources to undertake examination and enforcement activities. In fact, by 2022 to 2023, it is expected that the DFPI will have 90 positions and an overall budget of $19.3 million. This is truly remarkable in the realm of state financial regulation. The DFPI's primary purpose is to provide protection to consumers and businesses engaged in financial transactions. It regulates a variety of financial services, products, and professionals, and oversees the operations of state licensed financial institutions, including banks, credit unions, money transmitters, issuers of payment instruments and traveler's checks, and premium finance companies. The DFPI is charged with issuing licenses and regulating a variety of financial businesses, including securities brokers and dealers, investment advisors, certain fiduciaries, and lenders. The DFPI has broad authority to enforce the California Consumer Financial Protection Law, which prohibits unfair, abusive, or deceptive acts or practices similar to Dodd-Frank at a federal level. And it possesses this authority independent of the California Attorney General. A lot could be said about the politics of this reorganization, which occurred during the final years of the previous federal administration, when many consumer advocates felt that the CFPB was not being sufficiently aggressive with protecting consumers. But here we are in 2021 in a new administration with a CFPB that is expected to be far more enforcement-minded than it had been under the previous administration. And so we now face the prospect of having a very active CFPB and a new and highly motivated California agency that has been intentionally modeled after the federal agency and empowered to aggressively regulate the industry. Significantly, unlike the CFPB, the DFPI is permitted to retain settlement funds for its own operational expenses. Whether that will incentivize large settlements remains to be seen, but has been a frequent topic of speculation. Next. One great example of an area regulated federally that is also heavily regulated in California is privacy. The first major development came in 2003 with the enactment of the California Financial Information Privacy Act. This act is partially preempted by the Fair Credit Reporting Act, but it is not preempted by the Gramm-Leach-Bliley Act. Financial institutions must obtain affirmative consent to share non-public personal information with third parties under this law. The biggest fireworks came in 2018 with the enactment of the California Consumer Privacy Act, or CCPA, as I've said thousands of times in the last 3 years. You may have attended other Dorsey presentations on the CCPA or received one of our many client alerts. This has been a heavily covered topic in the legal industry, both because it represents a novel approach to privacy regulation that is more in line with the European Union's approach, but also because it has presented enormous challenges for legal and compliance departments to partner with their IT departments and communications groups in creating a technology and consumer inquiry infrastructure to support businesses' obligations under the CCPA. If your business is already subject to the CCPA, you likely by now are well aware of the existing requirements. If you are not yet subject to the CCPA, but considering business growth that could result in you becoming a covered business, we do have quite a few resources available to guide you through that process. Most recently, we have the even more controversial California Proposition 24, also called the California Privacy Rights Act of 2020, or Prop 24. This was actually a ballot initiative, and it's something of a mixed bag for businesses, clarifying some issues and confusing others. It isn't cause for panic, but yes, there is some more work to be done. Next slide, please. Now until January 1st, 2023, the CCPA in its current state will govern. At this time, the role of the DFPI is somewhat uncertain. On and after January 1st, 2023, Prop 24 will become effective, amending certain provisions of the CCPA and establishing the California Privacy Protection Agency to regulate this area. I'll briefly mention two common questions we get about California privacy laws. First, and somewhat indirect, but usually California is the understood subject, will Congress ever put an end to the state-by-state patchwork by enacting national privacy legislation that preempts individual state laws? Maybe. Certainly a lot of industry groups would like to see some consistency because it is difficult to navigate this patchwork, but this may be a careful what you wish for sort of situation. Congress could act to simply set a floor rather than a ceiling, leading to heightened national standards that still allow for states to enact greater protections. And that really is my personal greatest fear about additional lawmaking in this area. The second question that we often get is whether businesses should segregate their California data within their national databases in order to assist with their compliance obligations under the CCPA, such as consumers' requests to have their data deleted. We have generally recommended against that approach because it is unwieldy and often very expensive, as well as complicated to oversee. Most covered businesses have instead adopted more of a one-size-fits-all approach to offer the California protections to all consumers, because this is often a simpler way to go. Now, finally, a few additional points on privacy. You should be aware that institutions subject to GLBA, as I mentioned, they are only partially exempt from coverage. In addition, it's our opinion that robust data security measures will greatly reduce legal risk because the greatest economic and legal risks under these laws are with respect to data breaches. It is essential for all businesses who are covered businesses under the law to make sure that their privacy policies are compliant with CCPA requirements. This can make you a target. And covered businesses need to make sure that they have implemented processes to respond to consumer inquiries and directives. For example, requests for copies of the consumer's data or a directive to delete their information altogether. With respect to consumer rights under the CCPA and Prop 24, I want to emphasize that this is an evolving area. And until some of the lingering areas of confusion are clarified, it's our view that coming close counts. Next slide, please. And without further ado, I will turn the spotlight over to my colleague, Gabrielle Wirth, to discuss 5 California differences of concern with respect to labor and employment law. Gabrielle, the floor is yours.
Good afternoon. I know Joe said before that everybody wants to be a Californian, but after they hear our labor and employment laws, that isn't always the case. We wanted to highlight for you the 5 biggest items of concern that we're seeing now that surprise many people from out of state. The first is that California law is very different with respect to who can sue on behalf of other people. We do have the normal class action laws that most of your states have, and it's not that dissimilar from federal law, different standards, but the function's the same. But we also have our Private Attorney General Act, which allows any employee to sue on behalf of all aggrieved employees without meeting the standards necessary to be a class representative under the class action laws. And so what that law allows you to do is to bring a second kind of lawsuit in addition to the class action lawsuit that is on behalf of the state of California and cannot be waived by an arbitration clause. So for example, if you're not paying your employees on the last day of employment when they're terminated, there's a labor code penalty for that can be a class action for 30 days waiting time penalties. But additionally, because you violated the labor code, any employee can also bring a cause of action against you for penalties, which would be $100 for the first violation or $200 per pay period thereafter. And they go back 1 year and they add up to a sizable amount when you're adding it on top of your existing class action claims. So the moral of the story is, if you get something that says that it's a letter to the Labor Workforce Development Agency of the state of California, or LWDA, you need to respond to that immediately and get it to your counsel, because that is the first step that a plaintiff's lawyer is taking to sue you under our PAGA laws. The next area that surprises many people is that California is one of 7 states that specifically regulates meal and rest periods. Next slide. In California, employees must be provided a meal period if they work more than 6 hours a day. And the first meal period must start no later than the end of the 5th hour of work. This means that if you work 5 hours and 1 minute, you're in violation of the California meal and rest period. And the penalty is an hour's pay for not providing the meal period either timely or not providing the entire 30 minutes. The rest periods must be given approximately in the middle of each work period of 4 hours. And again, if you work a long day and you work up to 10 hours, you're entitled to either get a second meal period or a third rest break. That law surprises many people from out of state. The next law that surprises people is that we have daily overtime in California. Next slide, Joe. In California, if you work, we gave you a few clues on what to do in California on the meal break penalties. These are the general rules. And then on the next slide, we've given you some practical advice as to what to do if you're new to California. If you can audit the meal and rest periods, and you don't have to pay for one when the meal was actually provided, but the employee chose not to take it. So good practice is, when you see a meal period violation, to ask who requested you to work, why it wasn't an emergency that couldn't wait for you to take your meal period, or get a signed certification from the employee that they chose on their own to take the meal period late. Next slide. So the daily overtime kicks in after 8 hours in a day in California. There is a way to get around that and have a 4 10-hour work week, for example, but it requires a very specific process in California that involves written notice to the employees, a meeting where they all get to explain to them how the new system is going to work, and a secret ballot vote of the employees. And then it has to be, if the vote passes, it has to be filed with the labor commissioner. The importance of filing with the labor commissioner is that when a plaintiff's lawyer is going to try and sue you because they believe that you're improperly requiring a 10-hour day without paying overtime, they can look on the state website and see if you have properly filed your certification of the election. So that last step is a very important one. The fourth item that surprises people in California is the standards on independent contractors. In California, we had another ballot. We're very good at passing ballots with labor laws that aren't necessarily the most business friendly. And in California, we passed a law that codified a decision of one of our Supreme Court decisions, applying what's called the ABC test for contractors. What is hard for most businesses to meet is the second prong. The worker performs work outside of the usual course of the hiring entity's business. We've seen over the years a lot of entities try and reduce their workforce by laying off their workforce and bringing people back to do the same function as an independent contractor. Obviously, they're not going to meet the standard that it's outside the usual course of the entity's business. And then the worker actually has to be in an independently established trade, occupation, or business, meaning they're looking for a sign saying that, Gabrielle Wirth law practice, and that I hold myself out to the general public as being a lawyer for hire for everyone. So it's very different in California to establish an independent contractor status. And then the last one we wanted to focus you on, the fifth item, is our Labor Code Section 2802, because during these COVID times, that's very important. So Labor Code Section 2802 provides that you have to indemnify an employee for all reasonable and necessary expenses that they may incur. Reasonable and necessary means, do they have to have it for their business? And have they gone out of their way and spending way too much? In normal times, what this required you to do is, if you require employees to carry their own phone, you had to reimburse them for that. If they had to drive for company business, you had to reimburse them. But in these COVID times, it's really expanded what reasonable and necessary are. So working from home implicates personal computer if they're using it, their home internet, cell phone, even if they normally would have a landline at work, office supplies like printing, printers, cartridges, paper, mileage to the post office. Anything that they have to do in order to perform their job in California is something that the employer must pay for. Now, the big debate here was, well, what do you do? Many employers were saying, hey, my employees already carry their cell phones around. They're not incurring any extra money as a result of this. Or we pay 15 cents a mile if someone has to drive for us because they're already driving their car to work. Many areas of California, there's no public transportation. But the court in a case called Get Sutso said that you have to reimburse the employee even if the employee is not incurring an extra expense for the reasonable portion of the use of your personal computer. So for example, if a reasonable percentage of the phone, if the employee's business calls are 25% of the phone bill, they should be reimbursed, even if it was a $99 charge anyway, and it's not increasing the amount they're spending. Their car, they may have a leased car and it's not costing them anything to drive. You still have to reimburse them for mileage, and mileage that reimburses them for a proportionate share of all their expenses. Parking, that sort of thing. And some plaintiffs' lawyers are even arguing in California that what they may try and do now is for people that had to work at home during COVID, seek a reasonable cost of the rent or mortgage incurred by the employee in having to operate a home office, because many employers, banks included, have said you have to take reasonable steps to keep everything that you're using for work secure and to not allow anyone else into the office with where there may be consumer data, credit card numbers, banking data, that sort of thing. So although there's no rulings on that yet, you can expect the plaintiff's bar to maybe be looking to expand this law there. What we're recommending for right now is that if you're still having employees work from home, that you have a specific expense report that covers the work from home period, where you ask the employee if they have any extra expenses and allow them to submit for those extra expenses on a form. And again, 2802, being that it's a labor code provision, is something that's subject both to the class actions we talked about earlier and to the PAGA lawsuits, where an employee can say, I don't believe that the employer is reimbursing all employees for expenses that have been incurred at home during the period of time that they were forced to work at home. So we could spend a whole 8-hour day on the differences in California law, but these are the ones that are surprising to most employers who are new into California and are things that you should look into as you're first starting your way into California.
I want to say thank you to our panel for this interesting presentation, and also thank you to our audience for their attendance and attention. I do want to clarify the CLE code for this session is QWR 383, just so you have that. Please remember to sign and return your attendance sheet. If you have questions for our speakers, contact them using the contact information found in your presentation materials, or get in touch with your usual Dorsey relationship contact. Our next meeting of the Roundtable is planned for Thursday, June 24th. Please look out for your invitation, and thank you again.